Good morning, everyone. I'm just going to wait for you guys to trickle in. Happy Friday. How's everyone doing? Say hi in the comment. Hi, Tiana686. If this is your first time tuning in, definitely say hi in the comments so I can give you a shout out. Good morning, Everblessed. Good morning, Big Bag. Good morning, Earl Jojo. Edna Marie says, "Can I ask a question?" Yes, you can ask a question. She Shire says, "Happy Mother's Day." Thank you so much, and happy Mother's Day in advance to those of you who are mothers on here. Um, as I wait for you to tune in, Tiana says you look refreshed. Yes, I'm refreshed, because today is Friday. I actually get tomorrow off, so I definitely feel refreshed. Um, let me introduce myself. For those of you who don't know me, my name is Aisha Chidole. I'm an immigration attorney, and I represent clients in all 50 states of the United States and internationally with the family immigration matter as it pertains to the United States. So if you would like to immigrate to the United States, already in the United States, would like to adjust your status, naturalize, I'm happy to help you. We have offices in Florida and Atlanta, but we represent clients everywhere. My phone number is 407-995-6567, or you can also send us a WhatsApp, 404-333-8751. Today, is really just about frequently asked questions. So just get right into it. Let's get right into it. Ask me questions that you want to ask. I know that there's some questions that I expect to be coming on the new announcement that you guys probably saw that I posted about work permit renewals, which is amazing news for those who have renewal cases and renewal work permits. So let me just explain that really quickly again, for those of you who might not have watched the video or don't understand. So basically on May 3rd, USCIS, to clear some of the backlog with pending EAD, which is the same thing as work permit renewals, they have changed the extension requirement. So typically, if you file for a renewal of your EAD on time, usually you get a 180-day automatic extension, meaning your filing receipt acts as your EAD along with the expired card to show that you have a 6-month extension. But now what they've instituted as of May 4th, instead of 180 days for renewal of your work permit extension, you're going to get an automatic extension of 540 days, basically 18 months. So essentially, you have about a year and a half with the receipt and that expired EAD so that they can continue to work on your renewals. Well, hopefully by the time that time expires, you already have your green card. But the idea is that, to reduce the gap in people not having work or being laid off from work or because they don't have their work permit or, getting their driver's license and stuff like that. If you already have the receipt and your 180 days have expired, you're going to count an additional 360 days. So basically, you count from the date of expiration. So let's say you had an EAD. Gosh, my math is terrible, so forgive me if I make a mistake here. So let's say, so we're in May. So let's say your EAD expired on December 1st or something like that. So that was like 6 months ago. And your extension was through May 1st. Okay. So you're going to add an additional 360 days, essentially one more year to it. So it will expire next year, like end of April will be when it would expire. So you still are eligible to work. Now I know that I've gotten a bunch of questions about mostly on my TikTok about what if what was the question that people keep asking about this stuff now? How are they going to know? How do they explain this to the employer or whatnot and stuff like that? So the thing is, because it's so new, I can honestly say I don't know how USCIS is going to do it yet because we've not yet gotten any of the new receipts because it was just 2 days ago in the mail to see what they're going to do. But if it's anything like what they did when they did the extension for conditional green cards, what will happen is that they will send new receipts that would stay 540 days instead of 180 days. That's what my assumption is. But in the meantime, for those who have asked, I would suggest that you print out the rules on the USCIS website along with your receipt and your expired EAD if your employer needs it, so that your employer can verify and see that that is the rule as of May 4th, while we wait to see if they're going to send new receipt notices with the new dates. Okay. All right. Let's see some of the questions that I have. Earl Georgia says, once again, I'm happy to inform you I got my 2-year green card. Woo! Congratulations. That's exciting. Good morning, Chic. Blue Tron says, good to see you again, my lawyer. Hi. Somebody said, can you apply for citizenship while ROC is still pending? What is ROC? I don't know. Do you mean renewal of your conditional residence? Is that what you mean? You can just clarify. I don't know what that acronym means. Official TSO says, this woman got me my EAD after being in an abusive marriage for 5 years. I recommend her to even my enemy. Thank you so much. I really appreciate that. Edna Marie says, do you need a lawyer to remove conditions on your green card if you're still married to your partner? What's the timeline process for conditional removal of a green card? You need a lawyer for every immigration process. Just like with anything in life, you can try to self-medicate yourself, or you could go to a doctor if you want somebody who can care for you because they care for so many people that deal with that. It's the same way with anything legal. Yes, you can represent yourself pro se in anything legal, but why not get somebody who does this on a regular basis and has probably experienced all different case types, and just in case something happens. And a lot of times, and God forbid that anything happens to you and your spouse, but a lot of times, people are like, oh yeah, I got it in the bag, or think they know what they're doing. And then when they come to us, they've really goofed, and it's just much more difficult to help them. So I always say at least start with speaking with an attorney, or at least getting some counsel or consultation, to just know what you need to do, or what, you have at stake. And then in speaking of conditional green cards, since you brought it up, and I've talked about this before, but I just want to talk about it again. USCIS, again, something that you're trying to do to continue to speed up the process, which hopefully will be effective, is that they're going to start bypassing a lot of these conditional green card interviews. So if you have a super sorry guys, I have like lipstick on my upper lip and it's driving me crazy. If you have a solid packet. So it's not about, so do you hear what I said? A solid packet, because you could have a bona fide legitimate marriage, but your packet might not be solid. Because, I always tell people immigration is very strategic. You can have a wonderful marriage, but if you don't send or prepare your petition and add what it is that they need to see, you make things more difficult for yourself, and you make it harder for you to prove the legitimacy of your marriage. And I can't tell you how many times I've seen that. And I'm just like, oh my gosh, I can't believe this NOID. This person has a legitimate marriage, but like they have put themselves, like they have gone down through a rabbit hole that now to pull them out as a nightmare. But because they thought, okay, well, I know I have a legitimate marriage, I'm going to figure it out myself. So what I'm trying to say is basically with conditional green cards, when you are sending removal of conditions, you want to be very heavy in front loading proof of of the bona fides of the good faith marriage, because you can't just think, oh, well, I already gave them evidence when I was getting the initial green card, so I don't really need to give them stuff. And I've told you guys this several times with conditional green cards, you really need to show from the time you got your green card till the time the 2-year green card is expiring. You really need to show then that's the evidence they're looking at. They don't want any evidence that you submitted to them before you got your green card. So you really need to be proactive in documenting and keeping tabs of your relationship and experiences and things that show your marriage is real. And you can't wait. I've had people tell me that, and I absolutely hate bad mouthing any lawyer, because for all I know, it might not have been a lawyer that said this. However, I've had people tell me that they went to other lawyers and another lawyer said to them, well, You don't worry, you don't need to send anything. When they send an RFP, we can do that. That is ridiculous. If anyone is saying that, that is ridiculous. You should send everything that you can the first time, because one, you reduce delay, two, you reduce the chances of confusion or denial if you're not able to respond to the denial correctly, and three, you increase your odds of being approved. It's and finally, it's sloppy. It's sloppy work. Like, to me, that makes no sense. Like, when people submit only forms, like, immigration is not about forms. It's really about the evidence and how you create and craft and organize your evidence. So I'm going off on a tangent, but yeah. So with conditional green cards, if you do all those things, you will be bypassed for an interview. You will be bypassed for an interview. Sometimes you're going to need to call you for an interview, if there's just not enough stuff or they really want to hear more. I'm waiting to see what they're going to do about those who have waivers. So, like, those who are requesting waivers based on hardship, divorce, or abuse. I'm waiting to see if they're going to do more bypassing. In the past, we did have a lot of abuse cases that were also bypassed. But I'm hoping that it's going to be much more frequent, as long as they see all the evidence of a bona fide marriage early on. Okay, so I hope that answers your question. So Everblast said, is there a new update on USCIS website as to them giving us the exact timeline for all forms? So USCIS can never give you an exact timeline because that is dependent on human review. So they can't give you an exact date. However, if you go on USCIS case, you can Google USCIS case processing time, and then you can type in whatever form it is that you have pending. And then usually you have a drop box where you can select your location or the field or the service center, or the field office, basically, that's processing your case. Usually it's on the bottom of your receipt number, and it will give you a range of timeline. So what that range essentially means is that this is the range of how long it takes for us to process the case. You could very well be at the beginning of the range. Like, say, if they give you a range of like 5 to 10 months, you could very well be in 5 months range, or you could be in the 10 months range. But you'll be most likely in that window. Now, even though you're most likely in that window, there are always going to be people who sometimes get their stuff earlier than that timeline, and that is just a function of favor, and just, you're lucky with whoever had your packet, or maybe they didn't have a lot that they were reviewing and it was just easier. And then there are going to be people who are theirs is more than that 10 months. I'm using this as an example. Let's say it's something that has a range of 10 months. There are going to be people that have theirs later. A lot of times, when people have stuff later, there's usually something else at play if it's past the timeline. And that usually means either they're doing some more investigation on the person's record or history, or verifying something in their application that they sent. Or it could also be, maybe it's somebody who had like requests for additional evidence, and things like that. So the timelines might not necessarily be the same. So it just all really depends, but majority of the people will generally fall within the window of the timeline that they gave. Okay. All right, let me take some Facebook questions. Arhan's, well, this is YouTube. Arhan on YouTube says, do you have to do an address change with USCIS even if you don't have a case pending? No, if your case is, so if you've already completed your case, I guess it depends on what your case is. You have two options. You can do an AR-11 if you have a green card, or a conditional green card and stuff like that, and you're just updating your address. But if you have a permanent green card, you don't have to. Sandra says, happy Mother's Day to you. When it comes to you and your entire stuff, I'm a mother of 5 and I have 2 grandbabies, so I'm getting old. Happy Mother's Day to you. And again, happy Mother's Day to everyone. It's not an easy job being a parent, a mother, a father, or somebody who takes care of children that are not even biologically there. So happy, Mother's Day to all who act as mom. Good morning, Brandon. Good morning, Christy. Davis says, so good to see you once again. Hi. Okay, so good morning, Marsha. She says, good morning, great attorney. My question is, I already had a consultation with you for VAWA case, but what if my husband and I were living together but have no solid proof, such as lease, bills, etc., because he never put me in any of those? So we get this question a lot. And one of the things that is a symptom of abuse is not being included in anything. So while it makes it harder to show bona fides, but I think that's where your personal statement really matters, because you have to help USCIS officers connect the dot of why you don't have certain things. Because some people are so, you might have somebody who knows, say, okay, I am going to be so crafty in being abusive that I'm going to not leave any trace, well, one, of my abusive behavior, or two, where she can even try to get this green card without me. So that could actually be a form of abuse, showing that. But I'm sure that if we dig deep in enough, because I've had people tell me, oh, I have nothing, I've got nothing. And then we end up finding something. As a matter of fact, I'll give you guys a testimony. This is not a new case. This was a case from like either last year or the year before. I don't even remember. But this was somebody who came to us because they had submitted a VAWA petition with another attorney. They sent them a request for evidence. They submitted it, and then they sent them a notice of intent to deny, and they submitted it, but they were still denied. And when we looked, I was like, okay, we looked at his, that client was like, I don't have anything else. I don't have anything else. And they just started going through lists and lists and lists and lists of things, and let me tell you guys, like, I literally had this client go call Hotwire. Hotwire is like the company that does like hotels, rentals. Go call the I called the accountant that did it, because he couldn't get a hold of his taxes that he filed with a spouse. Like, we were able to show, one, the taxes, because the accountant was just so gracious, because we just could not get it from the IRS website to provide the certified copy of when it was submitted. We were able to 7 years ago get from 7 years ago, like, itinerary of them traveling, of them spending time in a hotel, to show proof of cohabitation, because they had a bug infestation in their house. But the point of what I'm saying is that not many attorneys or not many people will necessarily try to think out of the box to solve the solution, including you yourselves as clients, because you're not necessarily thinking that this is what makes or breaks your case. We literally had that, and about like four text messages that were enough to overturn the case, and he got his VAWA case approved. So what I'm trying to say is that a lot of times, let somebody else make the decision for you that you don't have enough evidence. If you go to a lawyer and they're like, you have enough evidence to push forward your case, like, why don't you deserve to push forward your case? Because look, you're already in a bad situation. You don't have any paperwork. You're living in an abusive relationship. If someone says, okay, let's use what we have, because at the end of the day, VAWA is about any credible evidence. So any credible evidence means there is no amount of evidence that is going to make or break you. We just need to see evidence that is credible, that makes it more likely than not that there is a marriage here and there is abuse going on. So you always want to think about that. Never let that fear, be what stops you from submitting anything and saying, well, I don't have a lease. Because everybody doesn't have a lease. Everybody's name is not on the lease. Some people don't have social security numbers, and some landlords will not agree to put them on the lease. So there are many reasons why you might not have a lease. But if you have other things, then you want to use all those other things. Don't let fear be what stops you. I remember I posted about my daughter jumping off a cliff, which had 20 million views, by the way, because different people were given different opinions about her jumping into the waterfall. Even though my children are competitive swimmers and divers, I mean, you guys won't know that because you don't know me personally. And it's very safe there. It's very safe and very secure where they were. But the point I was trying to make there was that a lot of times we as human beings, fear is such an obstacle from us moving forward in life, including when you're in an abusive marriage. The fear of what will happen of the negative is greater than the fear of what will happen of the positive. So I challenge most of you who are on this live, who are in that mental state, to ask yourself, well, what will happen if it works? Instead of always what will happen if it will fail, what will happen if it works? And any of my clients who have ever told me what will happen if it fails, ask them what I tell them. Like, I don't want that energy around me, I am a very positive person, and I believe that if you put your mind and set your mind to anything, you can manifest great things. Whether that's you as a Christian, I'm personally a Christian, or whether that's you as a spiritual person, or whether that's you based on your energy. But if you believe that something is going to go wrong, you will attract exactly what you feel. But if you cancel out that and just continue to confess and manifest, that everything will work out for me, everything conspiring, towards working out in my favor. I am telling you that you will have more positive results than negative results. Okay, Pastor Aisha, let me stop. All right, so moving on. Let's see what else we have here. Okay. Good morning, Colleen. Good morning, Chantal Buchanan. Happy Mother's Day to you too. Stephen Miller says, when your case had been forwarded to NBC, is this a good sign? Oh, you mean NVC? If your case has been forwarded to NVC, yes, that's a good sign. Usually it means that you've been, I don't know what your case is, what your case type is, but generally, if let's say you have a pending I-130, they can't forward it to NVC unless they've approved the I-130. So yeah, that's a good sign. So it just means that you're in the next level. Okay, so let's see what else we got here. Okay, I see some things in the question box. Let me try and see. Nikki Mara says, I'm a resident for 8 years. How do I apply for citizenship? You apply for citizenship by filling out the naturalization application. Depending on if you're a male or you're female, the requirements are different. If you're a male, between 18 to 26, you want to show that you're registered for selective service. It doesn't apply to you if you're over 30 and you never registered, you have like an exemption. And then, for everybody else, you want to make sure that you're paying your taxes. You want to make sure that, you have been in the United States as a resident of the United States, meaning continuous presence in the United States for at least 2.5 years of the 5 years before you apply, or at least half the time if you're doing it based on a 3-year green card. And then this is something that's very important that I want to talk about with naturalization, that a lot of people don't realize. It is about child support and taking care of your child. And this applies to you as a woman or you as a man. So what I mean by that is that if you don't have custody of your children and your children are minors, USCIS is not going to approve you unless you can prove that you support your child, whether or not there is a child custody agreement or not. I have had a client while we were there in an interview. The client had several children by different moms, so we had documentation for 2, and we had a letter from the other spouse, but USCIS called the spouse, right? Not the spouse, the other mom. I hate using the word baby mama, but you know what I mean, like the other mom, and confirmed that he has been taking care of his responsibility and his pain. And then we've also had the same situation when it's women, because women, you are not exempt from this. You're not exempt from this. Who's putting an angry face? Who has this angry emoji? Why? What are you angry about, Yoli? Anyway, so when it comes to women, it's the same thing. If your husband is the one taking care of your child, if your parents are the ones taking care of your child, as long as that child is not in your custody, you have to show proof of why, of how you support that child. The United States does not like for children to be maltreated in any regard. It does not like to feel that children are a burden to their parents or to the state. So this is something that determines good moral character. So good moral character, I will say, is one of the biggest reasons why people get denied for naturalization, because most things fall under good moral character. So you want to make sure you have that. If you have all those things, by all means, go apply for naturalization and you will get your citizenship. Okay. Trisella says, good morning from New York. Hey, New York. Happy Mama Day to you, Miss Aisha. Thank you. I'm waiting for my brothers and sisters sponsoring Priority Day to contact you. It takes so long. Yeah, it does take a long time for siblings. you're looking at anywhere from 15 to 17 years. This changes monthly, depending on the visa bulletin. The visa bulletin moves every month, so it just really depends on that. One thing I have to say to you, Trisilla, is I don't know if you're in the United States, but if you're in the United States and you're not in status and you're waiting on your brother and your sister, you're not going to be able to adjust. You're not going to be able to adjust your status in the United States if you've overstayed by the time the visa is available. You are going to have to do a hardship waiver. And the only thing that will qualify you for a hardship waiver is one of two things: your parents being either a green card holder or a U.S. citizen, or your spouse being a green card holder or a U.S. citizen. Those are the only two kinds of qualifying relatives that you're going to have to be able to get a waiver. So you want to be very mindful of if you're waiting in the United States for your sibling. But then again, I'm just saying it based on the rules today. The laws change every day in immigration. Just like I told you about the EAD like 2 days ago, we as immigration lawyers, we're consistently learning, so sometimes it's exhausting because they're just, immigration is such a political thing in this country, and I guess in every other country, because it's about people coming into this country and changing, the face of the country, that depending on who's in power and who's in politics, they change the laws. So it's like we're doing this thing one way today, and tomorrow we're doing another thing. As you're submitting this form, they're telling you this form is no longer good. Now this is the new rule. This is what we're going to do. So it's possible that things may change when that time arrives, but as of today, that's what it is. So you want to make sure you have a qualifying relative or that you're in status, because what is going to suck is waiting that long and then you're not able to still get the green card. Okay. Good morning, favorite Carrie. Long time. Thank you, Minaj. Okay, let's see what else we have here. Sandra says, because of you, I can have peace of mind. I can go to my bed happy because of you. You're a good lawyer. And everyone on this life, if they only will listen to you, it will work out for them, because it worked out for me. Oh my goodness. Thank you so much. You're going to make me cry this morning. I really appreciate it. That's what we're really trying to do at the end of the day. We just want to change people's lives. It's hard being in this country without status. It's hard, knowing that, your family back home depends on you and supports you. And there's a lot of shame saying, I came to America, I couldn't really, amount to anything, or I couldn't get a job. But let me tell you, nothing gives me more joy than seeing my clients when, maybe they got their work permit and they get respectable, dignified jobs. And at the time of those interviews, they're coming and, you can see even the officers are proud and happy to see them, oh, this one works at a bank. This one is a manager here. This one is a school teacher. And, it's immigrants are really, the face of this country. This country was built on the backbones of a lot of immigrants. So, it's our joy and our privilege, to change lives of people. Pauline says, how long do you have to wait for, and this is Pauline on YouTube, to wait for work permit when you file for VAWA? So it depends on what kind of work permit you file for. If you're filing for a work permit based on your VAWA petition, meaning you don't have an adjustment of status, you're not going to get a work permit until they make a decision on your case. VAWA cases take 2 years to 2.5 years. So you're going to be waiting a really long time. Now, if you attach an adjustment of status application because you qualify to attach one to it and the correct category is selected, then usually you're looking at 5 to 9 months. Knock on wood, the momentum from April will continue. In April, we started seeing a lot of work permits coming in at month 5, month 6. So we're hoping that it goes back to what it used to be before the pandemic, which was 4 to 6 months, because that would be great for, a lot of people. Okay, caution, Supermom says, please answer my question. Oh my gosh. I'm going to have to find it because there's so many questions, that it's hard to get everyone. I can't find it. If you can just ask it again or ask it in the question box. If someone applies for TPS, so they have to apply for asylum? No, TPS is not asylum. TPS is temporary protected status, which is only given to some countries, not all countries. So you don't have to apply for asylum. Asylum is not something that you just apply for. Like, you have to qualify for asylum to apply for asylum, meaning you have a credible fear of life injury or death because you fit into a certain class or group of people. Like, when people are like, well, I'm just going to file an asylum claim. I'm like, no, you don't just wake up and file an asylum claim. You have to qualify for that. Asylum has a really, really, really high rate of denials. A really, really, really high rate, like 90% probably cases of asylum get denied. I don't know statistically, I'm not a mathematician, but it has a really high rate of denial. So you have to have a really solid asylum case because you have immediate referral for deportation, if you don't get approved. So you don't just apply for asylum just because. TPS will at least give you 18 months of temporary stay, and hopefully they renew it. And while you're on TPS, you can also get a work permit. Everybody says, can someone file for divorce while waiting for VAWA? Her husband is driving her insane. Yes, you can file for divorce. You're not required to stay in a marriage that is abusive to you, because you submitted any kind of petition for that matter. The only thing that I will make sure you guys note is that if you do get divorced, you cannot remarry somebody else while you have a pending VAWA case. If you remarry somebody else, kiss your VAWA case goodbye. You have to wait till they make a decision. Kezzy says, good morning. My minor child got citizenship through me. How do I get a certificate for her? You have to apply for it. It's like it's a certificate of citizenship. It's a derivative. So it's like a derivative citizenship application. It's the N600, depending on what it is that you're looking for. So that's what you need to do. You need to apply for that. That's the only way that she'll get the certificate. Amandor Belinda says, can you apply for a green card as a domestic staff working in the United States for a U.S. diplomat? So I don't do employment based. I'm going to answer just a short snippet of your case, but you want to speak to an employment immigration lawyer. I'm a family-based immigration lawyer, but technically you could. However, there are steps to do that, and they first have to offer that position you're probably going to be looking at either an E3 visa. That's what will give you a green card. But your employer has to first be certified to then hire you. And how they get certified is that they have to apply, put that job requisition out for people here in the United States. And if they're not able to get it, or get somebody to replace that based on the timeline required, then they can petition for you. But your sponsor, they have to sponsor you. So you would have to talk to your employer about doing that for you. And then they can reach out to a business, immigration lawyer. Okay. All right, let's see. Okay, Caution Supermom says, what if you're eligible for a change of status through marriage, but your husband will not petition for you? So two things. Through marriage, it's not called a change of status. It's called an adjustment of status. Okay, that's what we call it when you're petitioning. Change of status is like, if you came here in a B1, B2, and you're changing to like an F1, or you have an F1 and you're changing your status to like a B1. So if your husband is not willing to petition for you, I suspect there's some stuff going on. So I would say that you definitely need to get evaluated to see if you qualify for VAWA petition. And if you do qualify, then you can self-petition by yourself without your spouse. And you're not going to need, with VAWA cases, you do not need a financial affidavit of support. You don't need anyone to support you. You don't need a joint sponsor. It is you, yourself, and you. And you can be in the same house with your spouse, and your spouse would never know what is happening. You get your green card and keep it moving. All right, let's see. Denise King says, can I adjust my status and get a work permit if I have a kid with a citizen so I can work and support my kid? So Denise, the answer would be if you are married to that kid's parent, the father or mother. Because if you're not married, no, you can't get one just by the fact that you have a child with a citizen. You have to be married to the person. Okay, so Kwashi says, what's your phone number? It's 407-995-6567. You can also send us a WhatsApp message if you want us to call you back, 404-333-8751. Oh my gosh, you guys seem, please answer my questions. I can't find these questions. So Eben says, can you apply for citizenship while removal of condition is still pending? The answer depends. It depends on if you can, but you have to be eligible to apply for it. So eligibility is if you have a removal of condition pending and you're doing like it based on you and your wife being, or your husband being still married, and you've been married for 3 years and you've had that conditional green card for 3 years, then you can apply for citizenship. What will happen is that they can't approve you for citizenship until they make a decision on your conditional green card. So they'll do the 2 interviews at the same time. Now, if you're applying based on, you're applying for removal of conditions based on divorce, you want to make sure that you've reached the 5-year timeline before you can apply for naturalization. So, yeah. Carrie says, what if I have evidence and police records but don't have enough proof of living with the spouse? Can I file for vow? I'm still married to him over 5 years. Yes, Carrie, call us. We can help you. 407-995-6567. Sir Cool says, do you recommend traveling on a work permit with advance parole? I can't give you any recommendations. I'm not your lawyer. You can do whatever you want to do. However, if the question is, are you eligible to travel if you're not in removal proceedings and you have advance parole and your advance parole has not expired, yes, you can travel. Okay, let me go to Facebook. Sorry, guys, I've been neglecting you guys. There's just so many questions on IG today. So Yali says, Yali, you have an angry face on my live, so I'm not going to answer your question. You need to change that angry face to a happy face, and then I'll come back to your question. So you can fix that. Diana says, can you file for citizenship for my daughter when you're waiting on adjustment of status? Without understanding what your daughter's status is, it's hard to answer the question because your daughter has to be a green card holder for her to file for citizenship. Okay. Okay. So Sid Sophie says, so my friend had his I-130 approved, but he was inadmissible. So the interviewer asked him to talk to his lawyer to send in a waiver. What are his chances of getting his 485 approved? Without seeing his case, I don't know what his chances are. Hopefully he has a qualifying relative that can show hardship. And if he does, hopefully he'll be eligible for the waiver. But it's hard to say if, I don't have access to the waiver or what's going on. So Yoli says, I don't know why it's angry. I'm sorry. Okay, fine. I'll answer your question. So she says, quick question. So I sent my I-130 2 days ago, and I would like to send in my I-485. Do you think it's too early to send in? Yes, it is too early to send in. Your I-485 will be sent right back to you. Since you sent in your I-130, you want to wait until you get your filing receipt for your I-130, because you cannot submit an independent 485. Something has to attach to the 485. So when you get your I-130 receipt, then you attach the receipt to your I-485 petition to say that you're submitting an I-485 on the basis of this pending I-130. Okay. Okay. So let's see. Taitsia says, let me see if you'll let me read this. My I-130 got approved, but the rest of my paperwork got denied, and I filed for an appeal to open my case back up, and I attached some document. It's been 3 months now. I don't know what to do. My husband is out on deployment. I don't know if that's what's making my process so long. So 3 months is not a long time with an appeal. Sometimes an appeals can take a year. Like I think the shortest appeals that I've had took maybe like 6 months. So you're still very new in the process, and you just kind of have to wait your time out. Okay. And then Alan says, How long after your EAD do you receive your travel card if you file for a combo? So, they always used to give combination cards when you file travel permits and work permits simultaneously. Again, something that they're trying to do that they announced in March to reduce backlog is they're going to be making the decision separately. Honestly, honestly, it's not uniform though. I'll tell you that. Like some days we still get people with a combo card, both their work permit and travel permit on the same card. Some days we get one with just the work permit and then the travel permit comes later. So it's really hard to say, how long after your EAD, but as long as you filed it properly and you don't have any RFE, hopefully it should come relatively quickly. Okay. So Mex says, what if you went with another attorney now want to switch during this immigration process? Honestly, every lawyer is different. And when and how you can switch. For me, I'm very, very particular about when I take on a client that is already with another attorney and what stage you're on your case. Like, I'm not just going to take you because you're like, I just want to jump ship, so, or like, oh, let me just put you on retainment, because there has to be something that I'm able to do for you. Because if you've already put in everything else, there's literally nothing we can do, unless we get some sort of RFU or NOID. So, you could switch, but every lawyer is going to have a different policy on how, or if they're going to take that case. So you would have to speak to the lawyer or whoever you want to switch with, and they'll be able to tell you. Okay. Peter says, my ex-wife canceled my kid's case. Do I wait for a response from USCIS before I can file for my kids? I'm a 10-year green card holder. Absolutely not. File for your kids today. That's messed up. Oko on YouTube says, good morning, beautiful. You're just awesome. Please, does an EAD approval mean the VAL petition is approved? Well, to follow up to that question, what is your EAD approval category? Once you type in what the category is, and I can tell you whether your VAL case is approved or not. Chanel says, what is the ideal time frame after divorce to get remarried without red flags? Honestly, I don't know. I don't know. I don't know. You just know that if you got divorced today and you got married next week or the following month, there are definitely going to be red flags. But again, red flags is just what it is. Red flags. It just means that it's going to create a further line of questioning. It doesn't necessarily mean that they're going to deny your case. It just means that they're just going to dig in deeper. It's really hard to tell. This is a matter of love, and relationships. Nobody can tell you, when you're ready to marry or when you're not ready to marry. So I can tell you that. Immigration can tell you that, as long as you can show that your marriage prior and the current one was legitimate. And then sometimes some people are in relationship. Sometimes people, even though they're getting divorced, they've been trying to get divorced for several years. So they've been separated for like a year or 2 years. So all those things count for something. So, I don't know what your own particular situation is, but those are some things that, they'll definitely take into consideration. Okay. Okay. All right, guys. I think this is going to be my last question because I can't keep track of all these questions anymore. Let me just see which one's good. So somebody said, what if you're divorced and filed for citizenship under the 5-year rule? So meaning that you've not been a green card holder for 5 years and you're divorced, you'll most likely get denied. What time was this? On the child security card. MZ Line says, good morning. I was told that if I do an adjustment of status and file for a permit to travel, I can get denied of reentry. How true is this? If you don't have any removal procedure going on or any removal proceeding, or anything like that, the odds are in your favor that you won't get denied. Sometimes you could get a call for secondary questioning, and then they will give you secondary questioning, but they will let you in. So again, if you don't have, and you want to make sure you don't have removals, because sometimes some people don't know. So you have to run your alien number on the EOR system to know whether or not you have anything pending. If you don't have anything pending, you should be able to travel if you want. Okay. Many of our clients do it all the time. Like even the ones that are terrified, and I'm like, go travel, go have fun, and come back. They will tell you, I'm sure some of them on the live here, and then they come back and send me an email. Thank God I listened to you. I enjoyed my trip, and I'm back. So, it's really up to you. So Oko Jim says class CO9. Okay, so this is relating to the question where you asked, does an EAD approval mean the valid petition is approved? Absolutely not. The CO9 does not mean the valid petition is approved at all. It just means that you have that pending adjustment of status, so we're giving you a work permit. Now, if your category said C31, then you know absolutely 100% that you've been approved for VAWA. Okay. Good morning, Tanique. Peter says, thank you so much. You're the best. You're welcome. Okay, let me see what else. This is a really good question. Meg Z says, after you receive your green card, are you able to travel any and everywhere? Absolutely. A green card holder has almost the same privileges as a US citizen. The only difference is one, you're restricted from how long you can be outside the United States. So, you never want to travel for more than 6 months at a time because you risk abandoning your green card, your permanent residency status, because you're essentially saying that if I'm going to be out for more than 6 months, then this cannot be a permanent resident. So you have a restriction of the length of time, but the same way that a US citizen can travel everywhere, you can travel everywhere. You can work anywhere. I mean, of course, some of the differences in citizenship is your ability to vote, ability to be elected, ability for jury duty, and then, of course, who doesn't want to be on the VIP line when you come back into the United States and they're like, go here if you're a US citizen and go here if you're not. I'll tell you guys a personal funny story. My husband was a green card holder my husband actually won the diversity lottery. And that was how he came to the United States. And he was a green card holder when we met. Of course, I'm a US citizen and our children were born here. And I remember when we had our child, they put me and the first child, in the US citizen line, and we just like, zoom, we just went through the line. And my husband was like, we were waiting for him. He was on the line for a really long time. After that, he applied for citizenship the next day, even though I'd been telling him for a long time to put in his application. But, so little things like that, those are some of the perks of being, a US citizen. But yeah, you can travel wherever. Akasa says, the lawyer and her team are top-notch, a circle of professionals and quick response to messages. The onboarding process is just outstanding with a well-detailed and explanation. Yes, tell them. Thank you so much. All right, guys. One more question. Last question, and I got to go. Okay, answered this one's. Okay. This person is asking, it's like a two-tier question. You're asking about citizenship, whether you can apply for citizenship. And you said you have a 2-year green card. You've had your 2-year green card for 3 years now, and you've been married for 5 years. So technically, you're eligible to apply for citizenship if you're waiting for removal of condition. Like I said earlier, they will basically make a decision on both at the same time. ICR, a valid petition takes anywhere from 2 years to 2.5 years. Of course, there will always be people that theirs get approved earlier or theirs get approved later. It's really hard to predict, but most people are going to fall within that 2 years to 2.5 years. People are saying, please answer my questions. Like, I don't see your questions, to answer them. Let me scroll through. Yeah, you can either put your question again, like I don't see them just because, the messages come so quickly, so it pushes everything up. FOIA, which is Freedom of Information Act, somebody is asking how long does a FOIA take? A FOIA is basically where you request all your immigration documents or what you've submitted, so you can see what your immigration history is, or it helps your lawyer to decide how to work on your case. That can usually take anywhere from a month, 2 months, or even it's no longer 3 months. I think it's cleared down since the pandemic, and it also depends on who you're asking the FOIA from. Is it USCIS, is it CBP, or is it EOIR? So all those determine how long it takes. Okay, Jabari says, what do you advise for someone with 2 years green card and his wife divorced him? So I can't give you legal advice, but if the person has a 2-year green card and their spouse divorced them, they can file for removal of conditions on the basis of divorce. So divorce does not stop you from getting your green card. If you have does not stop you from getting your permanent resident if you already have a 2-year green card. All it does is you have to just prove that you entered into your marriage with the intent of your marriage working, okay? But that your marriage did not work. USCIS are human beings. The officers are humans. So they also experience divorces, and they know that sometimes marriages don't work and sometimes marriages are short. After all, Kim Kardashian, she didn't marry her husband for immigration, and she only married what's his name, Humphreys, or whatever his name, Chris Humphreys, for 72 days. So sometimes you enter a marriage and you're like, crap, I gotta get out. It's not good. So just provide proof that the marriage is real. It's just that things didn't work out. Okay. All right, guys. I had fun chatting with you guys. I hope you have a wonderful Mother's Day to all of you on here who are mothers. And I will talk to you guys next week. If you would like to schedule a consult, I wasn't able to answer your question and you want to consult with our firm, you can call 407-995-6567. You can also send a WhatsApp 404-333-8751. And you can actually book your consultation yourself on our website. It's www.chidolwelaw.com. It's on all our profiles. So you can book it yourself. You don't even have to call us. So when people say, I can't get anyone on the line, or, I'm waiting for someone to come back, you can book it yourself. All right, guys? All right. Have a great day, everyone. Bye.